I want to thank you most sincerely for being here. There are so many worthy sessions, and we're honored as panelists here that you selected to our panel. We're extremely grateful. My name is Sofia Collin. I've been developing a jurisprudence called Unbounded law for about 10 years, and for about a couple years now, I've been working on a practical application of that jurisprudence called trust governance for lands experiencing disputed control or ownership thereof. So I'll get started. First, I wish to convey my most sincere gratitude to Swarthmore College and the Department of Peace and Conflict Studies for the opportunity to discuss trust governance. I'd also like to thank Professor Lodenthal, Professor Aston, and Professor Smithy for their time and very generous support in making this conference possible. Just as an overview, it's a presentation in 6 parts. I'll be focusing on lands, waters, and natural resources in conflict. I will then be proposing a new governance structure called trust governance. And then for those who might be unfamiliar with trusts or trust structures, I will be just briefly giving an overview of the parties involved in a trust, the purpose and function of a trust, and then what is trust governance. Following that, I will give a possible path to trust governance. What would that look like? How would it go from a request to an implementation? And then I will give briefly a summary of benefits and aims of trust governance. What are its ultimate goals, and how does it seek to be a positive governance structure for the people? And then I'll make concluding remarks. This presentation proposes a new form of governance for lands, waters, and other natural resources experiencing conflict as a result of disputed ownership or control thereof. In certain instances where such conflicts arise, creating a new nation, dividing the resources amongst the parties to the dispute, or yielding the land, water, or natural resources to another party's government or control may not be or may not result in a sustainable peace. Trust governance, or the no-state solution, proposes that lands, waters, or other natural resources in conflict may instead be placed into a trust, which is not a nation or state, and is administered by the parties claiming sacred right or connection with the land, water, or other natural resource as grantors and trustees, in addition to independent trustees who are selected by the grantors. The no-state solution, entitled trust governance, draws on the essential elements of the trust, which holds and administers an estate for the benefit of its beneficiaries, to construct a modified, irrevocable trust to hold disputed lands, water, or natural resource that is for the benefit of the people, which is administered by both the original parties to the conflict, those claiming sacred right or connection with the land, water, or natural resource, or a need connected to that land, water, or natural resource, as grantors and interested trustees. Independent trustees, those not claiming sacred right, need, and or connection with the land, water, or natural resources, are selected by the grantors to assist in the administration of the trust governance, and they offer stability, impartiality, and specialized knowledge for the benefit of the beneficiaries, the people. So what is a trust? A trust is a legal entity with 3 main actors. There are grantors, those who create the trust entity and place valuables into its care. There are the trustees, who act as custodians of the items held in trust. They have various responsibilities and duties, such as a fiduciary duty, and they are subject to removal for failure to uphold those duties, if they're in breach of those duties. Beneficiaries are those who will receive the benefit of the things held within the trust. Trusts are designed to separate what is called legal title from equitable title. So, trustees are endowed with legal title, which empowers the trustee with the authority to act as a custodian of the valuables. Beneficiaries are endowed with equitable interest or title, which empowers the beneficiary with the enjoyment or the benefits, fruits of the valuables which are held in trust. In essence, trusts are neutral, self-effacing vessels with the sole purpose of service to the beneficiaries, and they do not have an identity or an ego outside of their stated purpose. So what would a trust governance look like in maybe a pictorial form? As you can see way here up at the top, you have the land or water natural resource that's currently experiencing conflict, where parties are disputing control, ownership, or connection to that land, perhaps resulting in open war or some other conflict. And then the document is created, the trust document is created, and the land, water, natural resources are placed within that trust. Legal title is given to the trustees. As you can see, there are three types here. There are the interested grantor trustee, who would be a party to the conflict, who decides to place the natural resource into the trust. We have an interested trustee who perhaps wasn't a party to the open dispute, but does claim sacred right or connection to the land, so they have a trusteeship. And then we have an independent trustee who doesn't claim sacred right or connection or need of that land, water, or natural resource, but act as a stabilizing agent who invests their specialized knowledge, their experience in administering the trust. And as you can see here, there's the equitable title, where the people are, with the beneficiaries who have and are the beneficiaries of the natural resource which is held in trust for them. And also, I'll make a note, there is an independent judicial body that I'm proposing, which would assist in hearing disputes between trustees that can't be settled between or amongst themselves. They can perhaps access a court of their choosing, such as the ICJ in The Hague, or they could nominate another judicial body of their choosing, which they trust. And they can, of course, create a judicial body as well, which is similar to this trustee model, where there are interested judges, perhaps claiming sacred right or connection with the land, with independent or neutral judges who have no connection to that land whatsoever. However, this is all highly customizable depending on the parties, their unique concerns, and the natural resource that is being placed in trust. So a possible path to trust governance, it can start with an idea where Unbounded Law or myself receive a request for trust governance by a party to a dispute. On the local level, we identify all parties to the conflict, reach out to the parties regarding the request for a trust governance, and ensure that all parties with sacred right, need, and or connection with land, water, or natural resources are represented and have equal voice in and consent to the establishment and drafting of a trust governance. They may not be a participant in the open dispute, and they may be living abroad due to that dispute. On the international level, we'll need to reach out to partners such as the UN and possibly judicial bodies such as the ICJ regarding the request for trust governance, secure recognition in terms of possible reliance, and identify, retain experts, attorneys, and other relationships vital to the building of a trust governance, such as independent trustee, judge nominations. And then we will look at the funding level side of things. We need to create a budget. We need to identify existing resources, and then secure a bond, loan, donation, or other financing necessary, potentially contacting the World Bank in order to move forward in the drafting process. And last, we enter the collaboration phase where we begin drafting the trust with the consent and participation of all grantors and trustees, and interim implementation can occur symmetrically to sort out aspects of the trust that are not working as intended. What are the benefits and aims of a trust governance? Well, a trust governance prioritizes relationships and belonging over ownership or boundaries. Governance celebrates and encourages the flourishing of differences and leaves behind the cycles of violence, one, inherent in law, two, as well as in attempts to separate land by ownership or alleged superior connection. Trust governance prioritizes people over country. People are the measure of governance, not rule or ruler. Trust governance prioritizes law celebrating and supporting the common good. Peace as a presence, not an absence. And trust governance prioritizes the recognition of the value and harnessing of the power inherent in unity over the degradation that separation based on difference can foster. Separation of people based on beliefs or differences does not cultivate peace, but is another form of violence, creating disharmony and a breakdown in distrust in governance. Avoidance and separation are not neutrality, and harmony cannot be made without the difference of notes. Trust governance prioritizes and ensures that law is empowered by consent, not by violence or threat thereof. And finally, trust governance prioritizes the benefit of all people, not just a majority or a minority. All parties are equally represented in the decision-making process. To conclude, this peace architecture emphasizes collaboration, harmony, profound respect, selfless service, and the upholding of stability, safety, self-determination, and equal rights for all people. It is a governance for the people, for peace, and for celebrating our differences and the sacred facets of being that connect us to land, water, and to each other. Ultimately, trust governance proposes a self-effacing, humble alternative to national identity or national control of a resource such as land or water, which allows all parties to be valued while maintaining government neutrality so that people are not defined and bounded by governance, but free and empowered to identify and embrace their respective sacred beliefs and cultures in harmony and in peace together. So I want to thank you very much for your time and your consideration of my proposal. I look forward to answering any questions or concerns you may have. If you are a party or representative of a party to a conflict wishing to discuss the possibility of a trust governance, please do not hesitate to write to me or find me after this presentation. We can speak privately about that. Here is my website and my email, and forthcoming in the Indonesian Journal of International and Comparative Law is a paper that more fully sets forth this idea. So I want to thank you again. Thank you.